and to particularly consider the preparedness of their own families.
Question number 11, Charles Chauvel.
Thank you, Mr Speaker. Mr Speaker, my question is to the Attorney-General and asks, has the government given any type of indemnity relating to legal actions concerning Kim Dotcom? If so, what are the terms? And which agencies were consulted before it was given?
The Honourable
Mr Speaker, as was reported in newspapers on 24 May, an undertaking as to damages was given by the Commissioner of Police in relation to the foreign restraining order made on Mr Dotcom's New Zealand-based assets, and I refer the member to Section 29 of the Criminal Proceeds Recovery Act 2009. It's not related in any way to litigation surrounding the wider extradition proceedings or to criminal charges in the United States. It's not related to any other actions by government agencies. Undertakings as to damages and litigation are routine, but in this case, no minister, including the Minister of Finance, has any role in approving or signing off this kind of undertaking. That was the sole responsibility of the Commissioner of Police, and I refer the member to Section 92 of the same Act. I'm advised officials from a number of government agencies were consulted, including the Ministry of Justice, Crown Law, MFAT and the police.
Charles Chauvel.
Thank you, Mr Speaker. Mr Speaker, when the undertaking as to damages was being consulted upon, was the United States Ambassador to New Zealand or the United States Government one of the people or agencies who was consulted about the decision to grant an undertaking as to damages?
The Honourable Chris Finlayson.
Not to the best of my knowledge. In these sorts of things, in terms of international criminal litigation, the matter is one where the costs are normally picked up by the country that is requested to undertake the particular activity.
Charles Chauvel.
Can he explain to the House why, if the United States government was not consulted about the indemnity, material was withheld under the Official Information Act, citing the ground of disclosure being likely to prejudice the international relations of the Government of New Zealand? If he cannot, can he explain why that ground was cited in any other respect?
The Honourable Chris Finlayson.
I'm not privy to that particular decision that was made under the Official Information Act, but I imagine it was because of the general sensitivity concerning these sorts of matters, which would necessarily have a foreign component, namely, in this case, the United States of America.
Charles Chauvel.
Thank you, Mr Speaker. How likely is it, in his view, that the undertaking as to damages will be called upon?
The Honourable Chris Finlayson.
Well, as I say, it relates to the restraining order that was granted under the Criminal Proceeds Recovery Act. In terms of Section 28 of that Act, a certain amount has been released. At the end of the day, we have to wait until the end of the litigation or the expiration of 3 years to determine whether or not the undertaking would be called on, and then to determine at that point what, if any, damages would be payable.
Charles Chauvel.
Will the experience of the government in respect of the present litigation alter his position in respect of the advice he gives as to the wisdom of future such undertakings as to damages?
The Honourable Chris Finlayson.
Well, as I said in my answer to the primary question, the decision whether to give an undertaking was for the Commissioner of Police. As I understand it, under another type of legislation in 2002, the Solicitor General gave an undertaking in relation to certain damages that could be suffered if, as a result of that particular restraining order having been made, damages were suffered. As I say, undertakings as to damages generally in litigation where a person is seeking either an interim injunction or interim restraining order are not uncommon.
Charles Chauvel.
Can he confirm that in respect of this particular undertaking as to damages, briefings were given to ministers, including the Minister of Finance and himself, given the high-profile nature of this application to the court, and is he concerned that the Crown is going to be exposed to further damages in respect of the Dotcom litigation, given the admission of the Prime Minister yesterday that illegal actions had occurred in respect of the matters that were dealt with at the post-Cabinet press conference?
The Honourable Crispin.
I've already said that the undertaking is, in terms of Section 29(1) of the Criminal Proceeds Recovery Act, and that does not extend to any acts or omissions on behalf of the GCSB. It extends to the making, operation or extension of the duration of the restraining order. The first part of the question was whether ministers were given briefings on the subject. The answer is yes, there was a briefing.
Question number 12, Shane Arden.
Thank you, Mr. Speaker. My question is to the Associate